Hello, everyone. Welcome to LexTalk World's talk show presented by ClickAway Creators. Today, we have Mr. Noshir Kumana with us. Mr. Kumana is a solicitor with more than 4 decades of experience in civil, real estate, banking, and finance laws. He
As
has
well,
done lit yeah,
sorry,
he has done litigation in civil, cooperative law, rent act, commercial disputes, uh, and appeared before courts in Mumbai, Calcutta, Chennai, Jaipur, Delhi, and the Honorable Supreme Court of India as well. We actually have a lot to understand about him. So, without further ado, let me introduce you to the man himself. Hello, Mr. Kumana. Welcome to the show. And how are you doing today?
I'm perfectly fine, thank you.
Good
Perfectly
to hear
fine.
that, and thank you very much for getting some time out for the session from your busy
No, my
schedule. We
pleasure.
really
My
appreciate
pleasure.
it. Here's all us, sir. Thank you very much. And to begin with, I tried my level best to cover things about you, but because you have such a great experience, it's really not possible for me to put it in a way, in the way you can put it. So my first question would be, if you can put things in context for us and give a brief introduction about you and about your key practice areas.
Fine. Actually, I have completed 41 years in practice. Out of that, 43 years as a solicitor. Obviously, first I had to do my graduation, get my sanat, and then, which is the normal practice in Bombay, we have to sort of sign 2 years articles and then give our solicitor's exam. So in 1981, I got my sanat to practice. Then I sort of signed articles with a firm called Vinod Mistry and Company. And I completed my solicitor's exams in 1985. And I'm proud to say I was a rank holder. I passed in my first attempt and I was a rank holder in my solicitor's exams. Thereafter, I joined another very prominent firm, solicitor's firm in Bombay at that time, Matuvai Jamitram and Madar, where I sort of got an opportunity to have intensive exposure and training for litigation and property matters. In fact, I was very fortunate that I got actual training from a very senior solicitor at that time, Mr. Akbar Merchant. I'm really thankful to him. He's no longer there, God bless his soul. But he was the one who was sort of really given me the in-depth experience about drafting and property matters. Because at that time, just give a brief this thing, he was the sole solicitor for Aga Khan for all his properties all over the world. So he was a very prominent person. And such a prominent person selecting me, a very raw junior, to, he himself sort of told me one day that, would you like me to, teach you something? I said, it would be my honor. And with him, I owe my sort of expertise in drafting and real estate today. Then, of course, my litigation aspects. There also, I was supported by seniors at that time who sort of really gave me in-depth experience about how to appear, conducting trials, which was a very important aspect at that time. All that way, I've been very fortunate that, senior people have taken interest in me and trained me. Then in between, from 1989 to 95, I was with the corporate organization, Crompton Greaves. They gave me, they had invited me and had an interview with them and they had selected me. So for 5.5 years, which basically, according to me, is a rare thing for a practicing solicitor to be on the other side as well. So there I gained an in-depth knowledge about the working of corporates, how corporates work, what they expect from you. Because in the legal profession, we sort of say, okay, section so-and-so says this, and this can be done, this cannot be done. Whereas when you are in a corporate world, the company expects certain policies, and they say, okay, we want this to happen. Now, how to make it happen is for the legal department. And for that, I'm really thankful to my boss. He was the person who trained me of how to sort of adapt and how to provide the proper legal advice to the company, so that most of the projects which they wanted to could be implemented in a proper way within the legal framework, but sort of planning, not saying this can be done and this cannot be done. That sort of a thing. Then, of course, I left Crompton Gage in 95 and I restarted my practice. And that's it. From 95 onwards, I started as Kumana income on my own.
That is really brilliant, Mr. Kumana. Because you have such a great experience, I'm really sorry I'm slacking the conversation there. Actually, because I wanted to dwell down into case of yours, if you can put it that way, and then we can sort of continue your answer from there, if you allow me to do that.
Please. What exactly do you want to know?
So, generally, when lawyers come to the show, we are very intrigued in sort of understanding or knowing about complex legal issue that they or an interesting legal issue that they recently worked upon or they have worked upon in their career. And we also understand that every case in its own sense is complex. But if you can tell us about a complex legal issue that you worked upon.
Definitely. See, that way I worked upon 3 or 4, but I will select one of them since time limits. See, basically, this pertains to property tax, which is generally levied here in Mumbai. Property tax basically is a tax on the property. Any property owner has to pay property tax. Property tax is calculated on the basis of something called rateable value. Now, rateable value, what is rateable value and how to calculate the rateable value is as per section 154 of the Mumbai Municipal Corporations Act. Basically, 154, as it then was later on it got amended. In fact, it got amended due to that is a different story. I'll tell you how it happened, and due to my success in getting things done. So till at that time, till 2010, this system of 154 calculating rateable value, it was based on the annual rent expected from the property. It was calculated on the basis of that. What was the expected annual rent of any property, and based on that they would calculate the rateable value, and then based on the rateable value they would fix up your property tax. Now, sometime in 2010, yeah, sorry, 2001, the municipal commissioner, on his own, he passed certain circulars, internal circulars, saying that from that day onwards, directing all the assessors, because assessors are there for different wards. Each ward has an assessor who sort of assesses the property and calculates the rateable value and the property tax, and accordingly sends the demand for that amount. So he sent an internal circular to all the assessors in Bombay, saying that now property tax has to be calculated not on the basis of annual rent, but on an entirely different aspect, which was totally contrary to the provisions of section 154. So therefore, my client, he owned a building in the Fort area. That building, full building was owned by him. That building he gave on tenancy various premises to various people. And they in turn had, with the permission of the landlord, given those premises on leave and license basis to a nationalized bank. So based on that circular in the 2001, suddenly he got a demand of 3 times the property tax. 3 times the amount of property tax which was assessed and paid by him. Suddenly he gets a demand notice saying that now we have recalculated your property tax on the basis of rateable value and made a demand that now you have to pay this amount. So naturally, when he came to me, I said, basically, I studied the law, and then I advised him that the best way to do it would be to challenge that demand by way of a writ petition. Writ petitions are basically filed challenging any act or any I would say any act done by any government body or semi-government body. Now, Mumbai Municipal Corporation is a semi-government body. It's ultimately controlled by. So therefore, the writ petition was maintainable. So I filed the writ petition. Two of the main grounds taken in that. There were several other grounds, but two of the main grounds were that, number one, this internal circular, commissioner had absolutely no authority to sort of issue these internal circulars because the internal circulars were contrary to the act, and the act supersedes any internal circulars which are given in any government body. See, generally government bodies, what they do is there is a particular act. Suddenly they will pass a government gazette resolution, which is called GR, government gazette resolution, saying that no, this is not there. You have to do it in this way. So the law is very clear that the enactment is always supreme. Any act done by the government body contrary to the main enactment is bad in law. So therefore, that was one of the main grounds. Secondly, I took the ground of that my constitutional rights are being infringed. Because, I have been paying property tax regularly at the rate assessed as per law. And suddenly, I'm sort of burdened with a demand which is not payable 3 times of what it was. So ultimately, then I filed the writ petition, moved the Honorable Bombay High Court, and after arguments, Bombay High Court passed an interim order saying that yes, this demand given by BMC to my client was not proper, illegal, and therefore BMC was restrained, an injunction restraining BMC from collecting any property tax from my client based on that demand which was made till the disposal of the petition, because ultimately petition had to be finally heard. So an interim relief was obtained. So my client got sufficient relief. Now, based on my writ petition, which was my research, several other people filed writ petitions because my client was not the only one who was, burdened with this. There were several other properties. So several other advocates approached me, by how did you do it? What did you do? So I sort of gave them general guidelines, and based on that, several writ petitions were filed. Ultimately, after about 2 years, all the writ petitions were clubbed together and they were finally heard. And a common order was passed in all those writ petitions. And High Court set aside. It struck down that circular and said that this circular is totally wrong. The commissioner had no authority to do it, and then directed the BMC, okay, now you recalculate the rateable value based on section 154 as was. So substantial relief was obtained, not only to my client, but to various other people. That was a coincidence. I'm only on my client. My duty was to my client. So afterwards, they got very wise. And in 2010, ultimately, they amended section 154. And then they said, now as per section 154, rateable value will be calculated not on the annual rent, but on the market value of the property. They wanted to, forcefully collect revenue. So anyway, but my point is, for that particular I got my relief to my client.
That is very interesting case. Whenever we ask about a case, it's property case is not something that comes out of these questions, but this was a very interesting one. Thank you, Mr. Kumana. For
there
this.
are several other aspects, but I'm giving just one example.
Yeah, that I totally understand that. Also, whenever we say, or in your case, having 40 years of experience, You've seen a lot of development, or rather, I should say, a journey of the legal
Yes,
fraternity.
it has been a
Uh,
very long journey, quite a fruitful journey, with of course ups and downs always happen. But overall, it has been a fruitful journey. I have no regrets.
I mean, from papers to tablets, you've seen everything happening in front of you in courtrooms. My question is in regards to a very recent disruption or very recent activity that happened globally, the pandemic.
Right.
And in the pandemic, we saw courts begin moving towards more remote proceedings and availability. That was the need of that time.
Yes.
What do you think? Is this a sustainable way and a possible way to increase access to justice, in your opinion? What's your opinion on that?
According to me, it's a very good sort of move for basically two reasons. One reason being that justice is accessible to people throughout the country. Basically, otherwise, what happens is, for example, I am in Mumbai. Now, if some client from Calcutta wants some sort of legal advice or some sort of filing or whatever, right, then I mean, I had to physically travel to Calcutta or wherever. Here, with this mode, I sit in Bombay. Only thing which we do is we take the help of the local advocate for filing. And not only that, there was another aspect also which was very good, at least in Bombay High Court, that there was e-filing. So you did not need to actually go to court. You could file your whole proceedings online. So in that way, during the pandemic, it was very, very helpful. So the practice was not disrupted. Justice, implementation of justice was not disrupted. Of course, there are several gray areas in this, but basically there are, according to me, there are two major hurdles in India. I'm talking about the Indian scenario. One is internet connectivity. You see, internet connectivity in India is mainly there in all the major cities, metropolitan cities and one tier city. But in the lower tier cities, in rural areas, there is no internet connectivity. It may be there, I mean, a few connections may be there. So that has to be sort of addressed, and there should be internet connectivity all across the, so that people in remote areas could also sort of get justice by accessing it remotely. That is number one. Number two, even in our metropolitan cities, see, most of the internet connections are not stable, low bandwidth, breakage of, so that aspect has to be sort of looked at. Once that is done, according to me, it would be a real boon, not only for the legal profession, but for the business world at large. Because today I sit here and I talk to somebody in New York, interact with him, discuss with him. Previously, that was not possible because otherwise I had to actually travel or he had to come to India, spending time, money, etc. So in that sense, this is a very sort of progressive move. Now, the other aspect is not that the government has not done anything. There are certain positive steps taken, though many things require to be done, but at least a very positive effort has been made. Like, I'll give you an example. In Nasik, there is an e-center, dedicated e-center for legal proceedings, where advocates can actually go there, file the legal proceedings, appear virtually, and present their cases, and also get your legal knowledge accessing internet. Various judgments which are available online, they can access it. So that is one positive step. Of course, Nasik has started, hopefully, if there are centers established in most of the places, then advocates can sort of, not only advocates, even the litigants can have easy access. That is one aspect, good aspect, which our government has sort of, not government, I would say the judiciary has taken. Basically, this is established by And I would give credit to it to Justice Chandrachud, who is now our present Chief Justice. He is the one who has sort of taken this initiative. Second aspect is, most of the advocates, they do not have sort of computer literacy. In major cities, yes, but in rural areas, so computer literacy should be provided to them so that they also can represent their clients, gain knowledge, things like that. But positive step has been taken, and I am hopeful that in the near future things will improve, and even a common man would get easy access to justice.
All of us are, Mr. Kumana. So basically, what you're saying is it's more of a infrastructural issue when it comes to
Infrastructure and training. Infrastructure and training, both put together. Because training is also equally important. See,
that's a brilliant.
Infrastructure is available today, but training is lacking.
That's right. That's right. And awareness about it, and even we also have learned several reports say that we are not a law-loving society. You see, and that is a fact that came out of a lot of research. So that is also, I guess, awareness is also one of the key reasons.
Here, I would just like to put in one aspect.
Sure.
The legal scenario in India today, unfortunately, is that justice is accessible for the rich and powerful. See, common man, he has it, but he does not really have that much of easy accessibility to justice. So, I mean, these issues, if they're addressed, then even the common man can, approach and get justice. Ignorance again, because that is again ignorance. He should be trained. Yes, you can do this. You want justice, do it in this way.
That's right, Mr. Kumana. I mean, recently, just before you, we had a interview with a gentleman, and I mentioned that, as I said, we are not a law-loving society. Not, I mean, I won't say law-loving, but there's a saying that goes, I guess, in every family that friendship or, I mean, don't make a lawyer or a policeman your friend or your enemy. I mean, both are equally not good, not bad. They are on sort of a tight rope there. So we do not understand how law works. We do not understand how the justice works, and it's there for everyone. So that's very rightly said by you, and that is a fact. My next question is actually associated to that. Because you have seen a lot. So again, my question comes from that, from your personal experience. How would you rate the current legal system's drive towards encouraging access to justice? And is there a tangible movement in closing the justice gap?
Well, basically, I would put it this way, as I said in the past, that an effort has been made by our judiciary to provide accessibility. But as again, as I said, internet connectivity, more important is educating people that look, this facility is available. So please, make use of it. The first aspect which I always advise my client is avoid litigation. Do litigation unless, if you are really forced. But as far as possible, avoid litigation. Unfortunately, I'm sorry to say, but today's legal profession does not honor that. I have seen my glorious days. Justice was actually not only done, not only seen to be done, but actually done. Today, justice is seen to be done, unfortunately. So that, that can be done only if the mindset of people changes. You cannot enforce that. There can be no law. Okay, yes, unless you do this, you'll be punished. That will not work. People have to change their mindset. Please, I'm talking about myself, that I have been trained by my forefathers. This, okay, if you have something, if you give it and share it, it will grow. Don't keep it to yourself. Number one. Number two, if by the grace of God, you have been blessed with wealth, with knowledge, share it. Because sharing knowledge does not decrease it, it always increases it. Number two. Number three, forget egoism. Because sometimes, that has been my personal experience. Sometimes a very raw junior, he would give me some words of wisdom and some knowledge which even I did not. Why? Because I sort of gave him that opportunity of being his friend rather than being his senior. I'm not saying that I'm great, but that is the way I have always looked at life, looked at my profession.
These are very wise words, actually, Mr. Kumana. Coming out of you having such great experience, and there are a lot of things that we haven't mentioned about you. I mean, you are a member and paneled arbitrator of London Court of International Arbitration. So, I mean, you can say that you are good, rather great, and you can give your suggestions with having complete pride in your journey.
Here, may I add one aspect?
Sure, sure.
On the aspect of arbitration, because that is, a subject of my heart.
Yes.
I've been in arbitration for the last about now 12 years. And I have been doing arbitrations for finance companies, real estate, and insurance. As a sole arbitrator, as well as an panel arbitrator with the tribunal. And I have been fortunate that wherever I have had a tribunal, I have had the tribunal of ex-High Court judges and Supreme Court judges in several matters. And one, I mean, I have not again this thing blowing my trumpet, but I have the privilege of saying that in my 12 years, I have passed numerous awards, but not some of them have been challenged, but not a single award passed by me has been set aside by the court till today.
That is really that is actually something that we can underline for this session, and that's why I said, I mean, it's our pleasure, Mr. Kumana, to have you on this session today. There are so many things that we are learning from you, and not just me, but a lot of young viewers actually witness the
my message
discussion.
To them is, my message to any junior who wants to come is, be eager to learn, but for God's sakes, do not be dishonest. Work hard, endeavor, and you will succeed.
That was actually supposed to be my question. Your suggestion for young lawyers, and you actually gave an answer already to that. So I'm not going to enter into that. But my next question to you is, I was again, I don't know how to really put it, but all I want to understand is legal technology is now here.
Yes.
We are standing in the middle of it.
Yes.
In the middle of the era of legal technology.
Yes, definitely.
And in this era, there must be some tools that you use. So what are those tools that you use to make the task go easy for you?
I'll tell you. Basically, Microsoft Word, there is a function called track changes in Microsoft Word, where you change any document or any online. You get the document, you go into that track change mode, then you delete something, you add something, and it comes on the screen. And then that has made things easier for me. Why? Because previously what used to happen is, if I get a document, first of all, I had to read it. Naturally, here also I read it. But then, I used to make notes. Whatever suggestions required or corrections required, I used to make notes. Then I used to dictate it to my computer operator, my stenographer. Right? She used to type it out. In those days, first of all, there were typewriters. In my initial, computers came much later. In my starting career, I mean, there were only typewriters. So used to, give it, they used to type it. Then they used to bring it back to you. And obviously, they also committed mistakes being human beings. So again, you have to correct it, recorrect it. So a lot of time was sort of wasted. Now, with this track change mode, which I have adopted very smoothly now, because it took me a little time, but I've been able to do it. It saves not only time, but it saves a lot of cost also. Because when you type, retype, it involves a lot of cost. So that is one aspect of it, which I have, one of the tools which I use. Secondly, of course, is the internet, which provides now every legal aspect, any aspect of law is available. So if I have some sort of doubts or queries, I can go on the net, put that Google search, and I get it. Then accordingly, I read it and then interpret it. Number three, now judgments are available online. Previously, any judgment which was there, which I found interesting, I had to sort of maintain it in my diary. Now there are several portals, like Live Law is one of the ones which I have subscribed to also, where you directly it is available online. So you know the latest developments which have happened in law. Because any advocate, if he wants to be successful, he has to keep updated with the latest developments in law. Because law is fluid. It is not rigid. It sort of evolves through judgments. Ultimately, judgments influence the law. And judgments of Supreme Court ultimately are binding. So if you do not know the latest development, the latest updates about the law, then you advise your client, sometimes it may not be the correct advice. So unless you are updated with it, which I always do, I make it a point that at least about half an hour in a day, I sit on the computer and sort of do this research so that I'm updated with. So when a client comes to me, I can tell him, look, this is the latest thing. So this is how it is done, not that way. And third, of course, most important thing is our virtual meetings, which saves a lot of cost and time. Otherwise, previously, even conferences which I do as a solicitor, we exchange in property matters or any other matter to solicitors. Previously, the solicitor concerned had to either come to me or I had to go to their office, depending. Our norm is, the junior comes to the senior. So any junior person used to come to my office, but if I had someone senior, then I had to go to their office. So again, traveling, hassles of it. Now, directly it is online. Any conference, send the link, have the conference, finish it. And another aspect again is arbitration, especially international arbitrations. Now, it is accessible. Otherwise, you have to go there to the venue of the arbitration, the seat of the arbitration, which is called. Now, sitting here in Bombay, I can do arbitrations in New York, I can do arbitrations in Hong Kong. So that is the thing which I have adapted. Technology, which helps me in my profession.
That's wonderful, Mr. Kumana. I actually had two questions. One basically you answered about the young lawyers, your suggestion. If you have any other points, I would really love ask you to add up to that. But before that, time management is a thing that everyone
yes
suffers. And as they say, time
not
is
only
money.
as a lawyer, in any field of life.
Yeah, as I said, I mean, time is
management
money in
is very
any
important.
profession.
In any field, any walk of life.
Yeah, but in legal, it's most of all. That I must say. And my question actually is, how do you ensure to make the best out of your time as a lawyer uh, in your professional side of life and your personal side of life as well?
Personal life is a different aspect. I'll talk about the professional aspect of it.
Sure, sure.
Number one is every day in the morning for going to office, I devote about half an hour to go online. and look up the latest developments so that I'm prepared for anything which will come to me during the course of the day. That is number one. Number two, I sort of have daily planners and weekly planners, because that is very important. You have slots from this time to this time, scheduling of meetings, because you'll have several. See, last 10 years, I've been fortunate enough that I don't actually physically go to court. My juniors do. Previously, of course, see, if you are in court, you cannot plan time, because in court, sometimes your matter may reach, sometimes I have to, wait, practically the whole day for one matter to reach. So that time management was difficult. But now, since I don't have to actually go to court, I have that. So I have a planner. I have a weekly planner as well as a daily planner, so that I lay down my schedule. Wait, this week I have to do this. And then every day in the morning, immediately when I go to office, I chalk down. So at this time, this meeting, at this time, this time to this time, arbitrations which I have pertain to online or physical. Sometimes I do physical also. Here in Bombay, which are there, some arbitrations we do physical, but most of them online. So that time schedule is so that sort of is the manner in which I generally manage my time and efficiently manage it. I would put it that way.
That is very wise, Mr. Kumana. Thank you for the session. I mean, this has been a great session. But before I leave you, if you have anything to add on to that, again, the last question that I have for you is your suggestion for the young professionals who want to come into this fraternity, this noble profession, and who are already into the noble profession, trying to make their own way. What are your suggestions for that?
As I said, first of all, be devoted to what you do. I have observed, generally, that juniors nowadays, they are more interested in how much they are paid than actually trying to learn and devote time. So my main advice to them is, yes, money is important. It's not that it is not, but don't make that your main goal. Your main goal should be to learn. See, because as a junior, unless you learn, and secondly, don't be discouraged by your mistakes. Naturally, even I make mistakes, but a junior is bound to make more mistakes. But don't be discouraged by it. Learn from it, in fact, so that the next time you don't commit the same mistake. That is. Third thing which I would say is attend courts as far as possible, which I used to do in my junior days. If I was free from my other things, some days, you don't have many matters. But I never used to just sit in the office. Unfortunately, youngsters nowadays, they tend to, they don't sit in the office. They tend to roam around. You know what I mean? So my advice to them is, if you have that, go to courts, go to various courts, see how they function, see how matters are argued by seniors, and learn. It's a learning process. That is my advice to my junior colleagues.
That is why it's called practice, legal practice. So that is a very right point. Again, comes from a very wise man with wise words. So this has been a great session, Mr. Kumana, so far. And we have enjoyed this session. Hope you also have enjoyed this, and hope our viewers enjoyed this session.
I've just imparted whatever I have done, and I repeat that my belief is always knowledge is meant to be shared. If you don't share knowledge and keep it to yourself, it's not worth it. And I have been practicing that throughout my career. And in fact, I'm proud to say all my juniors who have worked under me, not only in the profession, my juniors in my service in Crompton Greaves, even today they remember me. That
I mean, Yeah, it generally, it actually does. And there are a lot of profiles that there are a lot of individuals that we talk to, and whenever we get a sense of value addition, someone who's more towards value addition side of the profession, uh, then it gives a sense of relief that the legal fraternity still holds a lot of thing that can be believed in from a common man standpoint. So you are that sort of ray of hope for us,
Thank
Mr.
you
Kumana,
for
for all of us.
thank you for saying that. It's very kind of you.
Pleasure. I mean, that's very kind of you to be so generous about what you do, and I promise to our viewers that we will definitely have you. And in our next session, we will be discussing more about the trending topics in the international legal industry, so that we can have understanding of different things from your standpoint, and you can put things in a layman's language for all of our viewers and for me as well. This was a great learning session for me. So thank you very much for the session today, Mr. Kumana. And as I said, we look forward to having a chat with you again in the future on some other training topics in the international legal industry. And
Thank you.
for our viewers, if you like this chat with Mr. Kumana, I want you, or I would say, I would request you to like this video, to share this video, and click on that red button to subscribe to Click Away Creators YouTube channel, to appreciate what we do. And you have more coming in from legal industry leaders like Mr. Noshir Kumana himself. This was Sagar for LexTalk World, signing off.